All right, let's hop right into it. I think a couple folks have exec noms is still happening today, isn't it? So we gotta get rolling here. So let's start off first. We're going to start off with obviously we held Senate Bill 250 for a clarifying amendment. I don't anticipate that the debate we're about to have is going to change the votes, and I don't want to relitigate the bill or the amendment that was slapped on. Senator West and I'll have counsel describe the amendment, Senator West's amendment to his previous amendment, kind of the problems that were posed, and then I suspect the vote will stay the same as it was last time. I don't want to open up this can of worms again, but so counsel Jamie, if you could explain.
Thank you, Mr. Chairman. So there is an amendment in your packet. It is Amendment 348-373/1. This is for Senate Bill 250. It's 348-373/1. There were some issues that were discovered with the language that was specifically adopted at the last voting session. So over the weekend, some clarifying language was put together. If you turn to the reprint and just page 1 of the reprint, this amendment incorporates what the committee did on Friday, altering the title at line 3, and then also adds language below line 14. And that language alters the definition of sexual contact, and in E2 says sexual contact does not include, and then go down to Roman 3, for only the purposes of section 3308B1 of this subtitle, in the case of two individuals engaged in an ongoing consensual sexual relationship, physical contact commonly engaged in by two individuals in a sexual relationship, unless one of the individuals has reasonably indicated to the other that further physical contact is unwanted. And that cross-reference to 3308B1 is specifically a cross-reference to the prohibition on engaging in sexual contact with another without consent.
Senator West.
Thank you, Mr. Chair. The advocates took a hard look at what we had done pretty much on the fly on Friday and concluded that just referring to Section 3-308 in its entirety was not good, and that we should instead refer to Section 3-308B1. I should note that they're still not in favor of the amendment, but I really think that we should commend them for fixing a problem with the amendment, and I would move the amendment that we have before us.
All right, so then we can reconsider the prior amendment and swap and substitute for the amendment that's before you right now. Is everyone okay with that? All right, great. So instead of, we're just going to record the votes as they were recorded before. So the folks that voted against the prior amendment are still going to be against this amendment. The amendment still carries. The bill's still the same, except with the corrections. Is everyone okay with that? Okay, great. Excellent. All right, thank you very much, Senator West. All right, we'll now move on to Senate Bill 17.
Senate Bill 17 establishes the offense of life-threatening injury by motor vehicle or vessel by criminal negligence. Under the bill, a person is prohibited from causing a life-threatening injury to another as a result of driving, operating, or controlling a motor vehicle or vessel in a criminally negligent manner. A violator is guilty of a misdemeanor and, on conviction, subject to maximum penalties of up to 18 months imprisonment and/or a fine of $5,000.
Oh, thank you. So this bill has had a long history. It's been introduced a number of years. Sometimes the Senate has passed it, but the House didn't get to it. Other times the House has passed it, but the Senate didn't get to it. It's Mary Beth Carosa's. It's been her top priority for years. I understand the House passed it either unanimously or nearly unanimously last week. And I just think it's time that we got the bill off of our agenda and agreed with the House. And it's a very modest bill. It won't apply in many cases. But let's get it passed.
All right, it passes without amendments. Okay, we'll now go on to Senate Bill. This is Heather. This Mr. Marchione. There'll be Senate Bill 369.
Senate Bill 369. This bill requires a local Department of Social Services that has a U.S. military installation located within its jurisdiction to enter into a memorandum of understanding with the Military Family Advocacy Program. There are no amendments in your packet. So under DoD policy required by federal law, each military installation and or unit, such as the Baltimore Recruiting Battalion, with 500 or more personnel must establish a family advocacy program and enter into an MOU with a local child welfare agency for reporting cases, providing services, and defining responsibilities when responding to a child abuse, neglect, domestic abuse, and problematic sexual behavior in children and youth. So this creates the MOU between the local jurisdiction and FAP.
All right. Any questions? Senator Bailey, you look like you want to say something. No? Okay.
That was favorable.
Did we just pass that? It wasn't.
Well, there's a motion and a second, so you do want to just.
Okay.
To make sure everybody's okay.
Everyone okay with this bill? All right. That's a favorable.
Hedelman 484.
This bill requires the State Board of Victim Services to develop a poster to notify victims of the right to request a private room in a law enforcement agency or unit to report crimes under Title III of the Criminal Law Articles, which is crimes against the person. The bill also requires each agency to display the poster and to provide on request a private room to a victim to report information related to such crimes.
Bill 484. Feel good, Senator Hedelman.
I This is in response to something that happened in a police department. I think we shared it at the hearing, where somebody, actually was a minor, came in with a pretty sensitive and private story to share and wanted some action and was forced to kind of relate it all in a very public way. So hence the bill. It was just to require that that law enforcement offer a private space, temporary private space to someone to reveal and to let them know that they have that option. That's it. Pretty simple.
There are initial concerns that the agencies would have trouble implementing it. Obviously, the fiscal note says that it can be implemented with existing resources. There was no opposition to the bill.
Right. And it passed the House.
Senator Carter.
Move the bill. I wanted to second the bill. Motion to move the bill, but I wanted to just lay the foundation that I think that this should extend to commissioners, and that when I come in next year with a bill that extends it to commissioners, I want the committee to be open to it and not think we've already dealt with the issue.
Noted. Duly noted.
Noted. So it's been seconded. Is everyone okay? Or do you want to do a roll call? Is everyone good? Is everyone okay? Or do you want to do a roll call? Everyone's okay. Okay, great.
Thank you.
Senator Lee with Senate Bill 331.
What's the bill number again? I'm sorry. 331. Thank you.
We're like NBA.
Hey, everyone listening?
You want Councilman Spencer to go first?
Yeah, go ahead.
Okay.
Sure. Senate Bill 331. This is adoption, access to birth and adoption records, and search, contact, and reunion services. Oops, sorry. So this bill repeals the right of an adoptee or biological parent to file a disclosure veto. Instead, these individuals may file a contact preference form that states the individual's preference for being/not being contacted. If an individual specifies that they do not want to be contacted, DHS will not redact their information from the birth certificate. If an individual filed a disclosure veto before the enactment of the bill, DHS will replace their disclosure veto with a contact preference form stating that the individual does not want to be contacted. An adoptee who's at least 18 years old may request a copy of their original birth certificate. If the adoptee is deceased, a relative of the adoptee may request a copy of the birth certificate. So to go over a bit of the background, just I think that helps understand this bill. So in 1989, the General Assembly passed legislation which caused adoption records to be treated differently. For adoptions that occurred on or after January 1st, 2020, these records were prospectively open and related adoption records to adoptees and adopted individuals and biological parents for all adoptions that occurred on or after January 1st, 2000. So when an adoptee turns 21 or older, they can file a request with the Department of Human Services for a copy of their original birth certificate. However, if a parent had filed a disclosure veto, they would receive a copy of their birth certificate, but the name of the biological parent would be redacted from the birth certificate. Adoptees or adoptions that occurred on or after January 1st, 2020 is different than how adoptions are treated before that. So if you were adopted before January 1st, 2020, you do not have access to your original birth certificate. So those birth certificates remain sealed. There are search, contact, and reunion services that any adoptee or a biological parent can request, where you request the assistance of an intermediary to assist reunion services. However, even if you want reunion services and you were adopted before 2000, you still cannot obtain a copy of your birth certificate, original birth certificate.
Senator Lee.
The bill is just about fairness. It ensures that adoptees have access to the same vital records and information about their origin, just like any other person has. The bill passed the House last year. We weren't able to preside over it last year because of COVID-19. And today, modern science and technology, anyone is able to find out about their genealogy or their background or about their ancestry, because DNA testing now is very inexpensive and accessible, like things like 23andMe and other sites and other services that has kind of made the concerns involving privacy moot. So it's not a privacy issue. When parents surrender their child for adoption, the parent doesn't have a permanent right or lifelong secrecy, and birth records belong to the birth, not the parents. The sealing of birth certificates were not meant to ensure permanent secrecy, and no other group other than adoptees does the government give permanent right to parents to seal vital records once that child becomes of age. So now the only barrier now for adoptees claiming their full identity and the right to know about where they came from, particularly for medical purposes, is this current law, which causes them to expend considerable funds and times just to get their identity. And under current law, as indicated by Heather, after the year 2000, they can get access to their birth certificates, but they would be blocked if a parent filed a veto disclosure. So instead, now this bill would just allow for a contact preference form to allow, just give information about how they want to be contacted or not contacted at all. And this is nothing new because other states have already done this. And so I respectfully ask that the committee vote favorably on this bill.
So does this bill that people who had previously, outside of, I guess, after 1999, I guess, is that the issue? If they had previously given a child up for adoption and they had signed a disclosure that their information would not be given out, this bill would now give out that information?
Yeah, go ahead, counsel.
I was talking to him.
Does this bill take people who have given children up for adoption? I think, is it post 1999? Is that what you're saying?
2000 is when the shift occurred.
Post 2000, who've given children up for adoption, they signed this form. And in part of the agreement, they said, "I do not want to be contacted. My information will not be given out." If we pass this bill, this undoes what these folks agreed to, correct? And their information is given out.
Correct. So if an individual, a biological parent, placed their child up for adoption after 2000, so under the newer system, and they filed a disclosure veto, if the individual, the adoptee, when they turn 21, they can request a copy of their original birth certificate. However, if a disclosure veto had been filed, the name of the biological parent would be redacted from the birth certificate. Under this bill, an adoptee, when they turn 18, not 21 anymore, they could get a copy of the original birth certificate with no redaction at all. However, there would be a contact preference form attached to the birth certificate stating that the biological parent does not want to be contacted, but the names would not be redacted.
So obviously these folks would have known that because it was blocked previously. So and there's a couple instances. One, it strikes me that this will discourage adoption going forward. People that don't want to give away their privacy will just choose not to adopt out children if we change this as a policy going forward, because it prospectively changes that too, right? Does it change that? So no longer can people say, "I want to be private, I don't want to be contacted." So the bill would discourage adoption. And then the second part of it, it undoes a contractual relationship. The state has told you, if you adopt this child out, we will not contact you. So now by passing this, we are going to break that contract. And I certainly sympathize and understand with people that want to find out who their biological parents were. But weighing that with the contractual promise the state of Maryland made you, my sympathies for them doesn't undo the legal responsibility that the state has contractually made a promise to them that we would not do this, and now here we are doing that. I don't understand legally how we can make an argument that that is a good policy. Sympathy, I mean, we can argue emotionally it's good for people, but I don't know how breaking a contract like this with somebody is appropriate.
Not all our laws are perfect, and sometimes we have to pass laws to ensure fairness and good public policy. And this is one of those times. Birth records they belong to the birth. They had no say in this whatsoever. They have a right to find out about their background, their identity, and particularly for things like their medical records and their medical health. So, I think that if anyone has to be protected, it has to be the person that was born. That birth certificate belongs to them, not to the parents. And I think this is good public policy, and it promotes fairness, too. And not, as I said, not all our laws are always fair or right. And we're in the legislature to, sometimes we have to change the laws to ensure fairness.
So I'm trying to think through this. It's an interesting bill. So as I understand the current law, if I'm adopted at any time in the past, I can go to the state and say, look, I'm 21 now. I'd really like to meet my biological parents. And I contact the state, and then they have an intermediary who reaches out to my biological parents and says, hey, Bob wants to meet you. Will you meet either mother or father? And if one of them says yes, and the state sets it up, and I can meet my biological parents. Isn't that right? Is that where we're coming from, counsel? Is that correct? Is that the current state?
The question?
Yeah, I'm trying to find out where we are right now. It's my understanding that where we are right now, the state of the law right now, is that if I'm adopted and I want to find out who my biological parents were, I can contact the state and say, I'm Bob, and I'm adopted, and I want to meet my parents. And the state then reaches out to my biological parents and says, hey, Bob wants to meet you. And if they say no, then it stops. And if they say yes, then the state comes back to me and says, we're going to set up a meeting with you and your mom or your dad or both. Isn't that how it works right now?
That is correct. Since you were, under this hypothetical, if you were adopted before 2000, you can
No, I
do
mean
this.
anytime, right now.
Even right now. So regardless of when you're adopted,
Yeah.
you can do this.
Okay.
The bigger difference is, even if you meet your biological parents, you can't go back to the state like, hey, I met mom and dad, or my biological parents. They say it's okay if I have my original birth certificate. You can't get it.
Okay,
If you're adopted after 2000,
right,
you go to the government like, hey, I met them, like, I want my birth certificate, or
right.
I never
Okay.
met them. It
So
doesn't
that's
matter.
an easy
You
one
can
to
still
solve.
get it.
An amendment that says if the parents and the kid consent to release the birth certificate, that's an easy bill. That'd be like such a non-controversial bill that could fly through with eagle's wings, right? So that's not where we are, though. It's not just saying, hey, mom and dad want to see the birth certificate. All right. So then I say, well, certainly health concerns are a big issue, but given where the state of the art is right now, what mom and dad can tell me about my biology pales in comparison to what I can get with a DNA test that tells me what my biology is. So that's no longer a relevant one. So what it really comes down to is just simply child wants to just know who the birth parents are. So now you have, all right, so, that's nice. I'm trying to think how that might impact adoptions going forward, because what I could see is there's going to be those cases where mom, most likely mom, perhaps dad, is in a position, they gave the child up because they were in poverty, because maybe they had a drug addiction, they were trying to move on with their life, maybe they didn't tell their future spouse that, yes, I've already had this baby and I gave it up because I was addicted or I was poor, or the child of it was actually a rape and I don't anybody know about the rape or something like that. And so they just wanted to move on. But now this child comes and meets them, and of course that makes it into the media, and it's a huge hoopla about how it destroys mom's life, maybe she commits suicide or something, ruins her family. It wouldn't take very long before these sort of negative stories about the adoption would get back, and every 13-year-old through 25-year-old would know intimately of these stories. Wouldn't we risk doing serious permanent damage to the whole practice of adoption, which I can't, from my involvement with the adoption world, typically because they do such thorough searching of vetting of the adopting parents, usually it furthers our public policy to an amazing extent. We take little kids who otherwise probably would have been failing in life, and we put them with parents who care for them and love them dearly because that's their only child or fills out their family. So why, tell me again this, Senator Lee, I don't understand, why do we want to jeopardize that? It just seems like you're saying, well, they just have a right. Well, it seems like we have a right as a society to say we think this adoption stuff is really good, great for society. So why do we want to jeopardize that? Just to satisfy somebody's desire to say, screw all this? Can you explain that to me?
I think the way we have technology right now, you could find out who your birth parents are anyway, but it requires a lot of cost and time and energy. And not only, this is a good public policy and fairness issue because the child is the one who has the right to find out about their background or identity. The child, it is the child's right. They had nothing to do with, they were just born. And I think that all these arguments you're making, we had testimony by persons that found their family and indicated that there have been some good outcomes. We didn't get any testimonies against this saying this was such a horrible thing because it damaged my life forever because I didn't want to get contacted by my biological kid. I committed suicide. Well, everything. We had a lot of testimony. This was just part of the testimony we see from a lot of witnesses that said they were very happy and they want this bill because it's the right of the child to find out about their background. And it reunites families, too. It's a good thing. Other states have had this law, too, for years, and there have not been, I heard of any terrible, egregious consequences that come out of this.
It unites families, but the current law lets you unite a family. But under the current law, if some of the family members are in a position where it would really be disruptive to their lives, they can push back. This forces reunification. I just wonder. I mean, I've got adopted relatives. It's not like none of us don't know people who are adopted and how that can impact families and all. It's okay. You're just willing to roll the dice and perhaps destroy the institution of adoption. I find it an incredibly valuable tool, and you're just giving me hypotheticals, quite frankly. And okay, thank you.
Just going to say, lastly, too, I mean, there are two parties. I understand the right to the person who wants to know, but there's a right to the person that signed an agreement with the state. They have a right, too. There's two parties to this. And second off, you're talking about people who, at the moment they gave the child up, said, I do not want to be contacted. The child turned 21. They tried to contact them. They said, no, I don't want to be contacted. So then you're saying, okay, we're going to break both times. At the moment of adoption and 21 years later, the person said no. Now you're going to break that and come back and say, nope, we're giving you a name. Just go ahead and show up at their door, invade their privacy, whatever. I mean, it seems right now it's a very fair system. Even when they said no, the state will try to ask if you want to be reunified, and the person still has the right to say no. So to do this is just to breach their contract.
Thank you, Mr. Chairman. I'm a strong supporter of contracts. But in this case, there are going to be many people who put their child up for adoption prior to the time that we knew that how to deal with DNA and how important DNA is in terms of ultimate health, as well as other health information. I just think as a health issue, it's important that a child who was adopted have a right to find out who his parents were, and if a health issue has arisen, would be able to go back to them and to try to ascertain what this means in terms of his ultimate health or her ultimate health. So I think they're good arguments that have been expressed. I just disagree with them.
So, Mike, I think in today's day and age, when we all grew up, I definitely knew some young adults who utilized the fact where they had children that they gave to adoption. The children were benefited from it, and those young adults in a very vulnerable stage benefited from it because they knew that what they were doing would be anonymous. I've also known some other young adults who didn't give the child up for adoption, where they went ahead and they had an abortion. And as a result of that, in particular, they have had serious mental issues about that growing older. And so I think that what is done in the contract initially for these people is important. And the second is, I think that there would be young adults that would maybe change their views and say, I'm not going to give this child up for adoption, right? And so I would not support this bill.
Really to Senator West, you say it's for the health. I mean, 30 years ago, that argument would have held water with me because we didn't have genetic searches, but it seems like that argument holds less water with every passing hour as genetics, the science of genetics just takes off. And now you can get a genetic profile that discloses your predilection to all kind of diseases, your family history and the like. It won't tell you exactly who your parent was unless they're also in the database. You can find out an exact DNA match, but you would know. So, if we've gotten this far without it, I'm just not following, the logic of that, because you're saying, but that's what's selling you. What's selling you is that the family history would matter, and I'm suggesting that that's no longer a valid argument. Maybe you could, because I certainly care about people's health too, but it's one of those arguments that's sort of on a collision course with reality that it quite frankly doesn't matter what your parents want you to know. You know your genetics. You know what your susceptibility to heart disease and cancer and a whole bunch of other ailments that probably your parents don't even know based upon family history because people didn't follow that stuff as much.
To that argument too. So you go back when you're 21 and you reach out and they say nope, they still don't want to talk to you. You use this bill, you break it. You go back, the parent is presumably in their 40s, let's say. They had the child when they're young, 20, 21 years later, 41. Knowing their name tells you what? You're going to Google their health history? I mean, what is that going to tell you? You go back, I guess, find their genealogy and find out if there was heart attacks in the past or whatever. I mean, what people are going to do is they're going to show up on their front door and knock on their door. I think that's what's going to happen. But what does that tell you? Because a 41-year-old, what are you going to glean from knowing their health history? And you won't have it unless they willingly give it over. They didn't want to give you their name. They're not going to give you their health history.
Well, this assumes that they continue to hold to the same views when they're in their 40s that they did when they're in their 30s.
Asked right now under the current system, they say no when they give you up. You can go through and you're blocked, and they will reach out again. If you say, I really want to know this person, then they'll reach out. You're 21. The state will reach out on your behalf to the parent. The parent says, no, I don't. I told you no when I gave them up. I don't want them to have my information. So now this bill will come in and say, they said no when they gave you up. Then 21 years later they said no, but we're just going to come in with a bill and break it. So at that point, why would they? They're not going to give you anything. They've said no twice, 21 years apart, that they don't want to talk to you. Why would they then willingly, well, here's my health records.
Okay, I guess I'm up. There's nothing that forces them to give DMA samples or whatever. I can tell you, every time I go see a new doctor, I need to fill out a long form with lots of questions. And a number of the questions are about my parents. Did my parents have this or that or this or that or this or that? If I don't know who my parents are, I can't fill that information out, and it could affect how the doctors treat me. So I just think from a health point of view, it's important to allow the children to find out basic information about the health of the parents that would help them with their own health.
So, but what would you glean if you have tried to reach out to me recently under the system. I've said no. I don't want you to know who I am. I do not want that. Then this law allows you to get it. why then would I say, well, I said no, I don't want anything to do with you. Why would you get any information from me as a 42-year-old where I already said I wouldn't give you any of that? What would you glean from that?
Well, if the parent confronted with the need of the child for health information still says, no, I'm not going to give you any information about your background, my first reaction is shame on the parent. But beyond that, there's nothing the child can do. But I suspect that in most cases, if the child goes to the parent and says, I need this information so I can help myself in terms of my health, most people are going to, if it was their natural child, are going to say, fine. I will give you the DNA sample that you see.
Okay, so they're going to go from saying, I didn't want you to even know who I am, to, I'm going to send you a DNA sample. I just think, look, we as a state, to encourage adoption, have said you can give a child up in privacy. So not only does this policy lessen the people to give up people for adoption, which I think is a bad policy, but second off, it goes back and breaks the word. And the idea that these people are going to magically go from 1 month saying, I don't want you to even know who I am, to the next month sending you DNA samples and medical records, I don't think that's plausible.
You're right. All we have to do is amend the law on disclosure to say, if you don't want to meet with Junior, will you fill out this 5-page question on health, which will not give the name of the parents, but will tell them everything about mom, dad, siblings, grandparents, great-grandparents, all the way back. Because if you're right, then that's an easy fix. You don't need to get it from the parent directly. The state can get it from the parent and pass it over to you. And that's and I wouldn't have any problem with that, Bill. Just, hey, I know you don't want to meet. If you want to meet with them, this is too easy. Go figure it out yourselves. If you don't want to meet with them, would you at least give the kid the benefit of the health disclosure? Give them this, fill out this detailed family history form, and give it back to the state, and they'll give it to Junior, and then they'll have all that information. It just really gets back to the issue of, if this person, they're in a position in life where she never told her husband and her kids that she had this child at 16. And now, boom, unloaded on the family. What's the impact of that going to be? You possibly destroy the marriage. A lot of issues come up because people relied upon moving forward in their life that wasn't going to be disclosed. And now she's been married for 25 years. Should she have said? Probably should have said something, but she didn't. So now, boom, you've destroyed the trusting relationship in that marriage because the decision she made at 16, or him, same thing with him. So he fathered a child at 17. But now, boom, it's out in the open, and his past comes back to haunt him 30 years later, 20 years later. That's really what we're doing here. And the only reason, there's really no practical reason, because we can solve the health issues. We have genetic testing. We can provide a disclosure form. All this can be done without forcing people to confront these issues. And I don't see a practical side of that, other than to say, as Senator Lee does, well, the child has a right to see the original birth certificate. And I say, well, yeah, the child also had a right to live in squalor for the first 21 years of their life and be raised by a mom or a dad who had no ability to do that. They had a right to do that too. And fortunately, this nice young couple came in and took them out of that and raised them. So anyway, vote what you want.
We had a hearing when those situation scenarios, they could have come in and said that, but we didn't hear anything like that. As I said before, birth records belong to the birth. We're trying to make good laws here, and I think the current law is not good policy, and I think we have to ensure fairness. No other group than adoptees does the government give a permanent right to parents to seal a record once a child becomes of age. So I would move the bill favorably and just roll it.
Hearing that the birth record is the record for the child, obviously I can get my own birth certificate, but I'm just curious, as a matter of current law, if my mother, who's listed on the birth certificate, wanted to get a copy of my birth certificate, would she be able to get that under current law? 'Cause, she's on it. I would imagine.
Born before 2000 or whatever, 99. Under the old system or the new system?
No, unrelated to adoption. Like, if my current mom wanted to get my birth certificate to show that she gave birth to me, for whatever reason needed that, would she be able to get that birth certificate?
I'm reading through it. Give me one moment to locate the answer. If an adoptee is at least 21 years old, a biological parent of the adoptee may apply to the secretary for a copy of the adoptee's original birth certificate. So it depends on the age of the adoptee when the biological parent can apply for a copy. Yeah, so if an adoptee is at least 21 years old, a biological parent of the adoptee may apply to the secretary for a copy of the adoptee's original birth certificate.
So they can't do it before the child is 21?
No, they have to be 21. This bill would make it 18. And it would also open it up, so under current law, that's what I just said, under the bill, it would change it to, if an adoptee is at least 18 years old, a biological parent of the adoptee or the biological parent's relatives, if the biological parent is deceased, may apply to the secretary for a copy of the adoptee's original birth certificate.
What about, forget adoptee, what about just parent?
It's based on the age of the adoptee when the parent can apply for the certificate.
No, but just remove everything out of the construct of the adoption sphere.
Mm-hmm.
Let's say my mother wants to get a copy of my birth certificate.
Mm-hmm.
Can she do that? She can do that. Unilaterally without my approval, or what?
I
How does
don't
that
know.
work?
That's a different section I'd have to look into.
Was that your question? You're good. Okay, we're good to go. Okay. All right. So it's been motion's been seconded. So let's do a roll call. Motion's been for favorable. It's been seconded.
Vice Chair Waldstraker.
Yes.
Senator Lee.
Yes.
Senator Castle.
No.
Senator Heddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Bill passes.
Favorable. Okay. Now we'll go on to Senator Lee again with Senate Bill 675.
So this bill exempts the transfer of a used vehicle from a business entity to an individual who wholly or partly owns the business entity from the requirement to obtain a motor vehicle safety inspection certificate. The House cross-file, which is House Bill 1315, passed the House unanimously with an amendment that limited the exemption to a transfer from a business entity which has been or is being dissolved to the majority owner of the business entity. You can see the third reader version of that bill in your packet. The House cross-file is 1315 by Delegate Fraser Hidalgo.
to your business, hold on. Josh, this just says if you own a vehicle, is it your business, you give it yourself personally, or vice versa? You don't need to get it inspected again, right?
Yeah, so the bill as drafted just applied. Any used car owned by a business entity that's being transferred to an owner would be exempt. And the amendment kind of limited that a little bit.
All right, and there's no opposition, right?
As drafted, there was some opposition, I believe, from some consumer groups. From the Consumer Protection Division of the AG's office. And I'm sure that I don't know whether they are now favorable with the amendments, but they certainly address, to an extent, the concerns that the AG had.
I mean, if it's your business entity and you're giving it to yourself, inspections cost hundreds of dollars, all the little stuff you got to fix.
Thank you, but am I right that it could be an unrelated party, or no? Is that what the amendment addresses?
So as the amendment is limited, it has to be a majority owner of the business, and the business has to either have been dissolved or be in the process of being dissolved.
Gotcha. Okay, thank you.
Second.
Everyone go with the amendments? Got it. There's been a motion for favorable, it's been second. Is anyone against the bill? Okay, great. All right, we'll now move on to Senate Bill 187, which is Senator Sidnor.
Senate Bill 187 establishes requirements and procedures for forensic, genetic, genealogical, DNA analysis, and related searches of publicly accessible databases using genetic profiles. The bill also includes provisions regarding regulation and oversight of testing connected to this analysis and direct-to-consumer genetic genealogy services. There is one amendment in your voting packet. It is Amendment 273-728/1. So this is Senate Bill 187 for Amendment 273-728/1. The amendment conforms the bill to the House version with one exception. The amendment, there is a list on page 4 of the reprint. These are the situations that this sort of testing can be authorized. The House version included a greater number of offenses that this could be authorized in. As this bill is amended, it would be allowed in situations where there's a murder, rape, felony sex offense, or criminal act involving circumstances presenting a substantial and ongoing threat to public safety or national security. So that would be the list of offenses that this would apply in, and I believe the House had a more extensive list. So that's the changes that the departure from this version and the House version.
Thank you. And if I may just to add, as testified to during this bill hearing, I initially started working on this legislation about three or so years ago. I had a bill last year that I pulled back because it had some drafting problems, and I've been working with advocates or stakeholders, I'll call them stakeholders, for over a year, so that there was balance and input from everyone. So at the hearing that we had before the Senate, I believe the opposition that you heard came from the state's, two members of the Maryland State's Attorneys Association who were invited to be a part of our discussions. After that hearing, we had a good conversation, and they realized that some of the things that they were speaking out against were actually addressed in the bill, and they were mistaken. They were concerned. They had expressed some concerns that they believed that the Maryland State Police had, but again, the Maryland State Police had been in attendance at all of our meetings, and they were, I believe, good with the bill, but for one provision. All of those types of amendments and things that a number of the organizations or stakeholders were looking for were addressed. So I think the last thing that you all may have heard was from the Coalition for Genetic Data Protection, which consists of, I think, the Ancestry.com as well as 23andMe. They were concerned about being regulated not only by federal government, but by the state police. We had conversations with forensics from the state police. They offered their opinion. We made a few more adjustments that the Coalition for Genetic Data Protection were okay with. So those amendments have been included in this. So as council noted, the only thing that's different between the bill that you all have before you and the bill that was voted out of the House unanimously is Section 17-102, where it talks about the types of crimes that this particular technology can be used for. And the reason being is these are crimes that, again, our stakeholders we came to, we thought it was either the most egregious ones, given that technology is so new and in some cases has been fraught with some deception on parts of law enforcement. We wanted to make certain that if used, it was going to be used in the most heinous of cases. That's why you see murder. That's why you see rape. That's why you see the felony sex offense. The last category, the criminal act involving circumstances presented a substantial and ongoing threat to public safety, that was included at the urging of the Maryland police, the chiefs and sheriffs, in case something were to happen. But the idea from our group is that this particular technique is ultimately going to be used as something of last resort. So this bill, it provides judicial oversight. That's what Section 17-102 is about, or partially what it's about. It ensures that there's notice to users of some of these direct-to-consumer sites like 23andMe, Ancestry.com, GetMatch, which had a history of putting up a policy and then going against this policy because they wanted law enforcement to solve a crime. It includes data expungement that law enforcement has to do for people whose information may have been caught up, and there were third parties that were not suspects. So that information has to be destroyed. It also allows for defendants to have access to the same type of technology, and it creates under Section 17-104 a licensing regime to make certain that that they're operating in accordance with the state law. And finally, under 17-105, we create a annual reporting requirement, as well as a panel that's going to be looking at and making suggestions as this technology is used in Maryland to ensure that if things need to be tightened up, we have some eyes on it and the like. So if there are any questions, I'm happy to take them.
Thank you, Mr. Chairman. I like the bill. I like your explanation. I'm looking at the testimony, and I'm wondering why the Maryland Judicial Conference. I'm trying to discern what their challenges really are that haven't. Have you had a conversation with them other than their testimony?
Found their testimony. All right, so I would say within and some of these the houses.
Yeah, I think
markets,
105 is addressed.
Right.
That was one of their concerns, so I know that was addressed. But I was just wondering, did they reach out to you other than submitting the?
No, we have not had a conversation thereafter. No.
Okay. All right.
All right, let's do this. Can we at least stop the amendment so that we can speak off of the amendment? All right. Everyone's okay with that? Excellent. Further discussion? Sure, Senator Kessler.
About the bill.
About now the bill is amended, so just now about the bill.
Yeah, I'm trying to understand. And there's a lot of restrictions in here, maybe just sort of in layman's terms. For example, it has a big piece here on third party and third party DNA. It's a complicated bill with a lot of different types of DNA or collections, or there's FGG and FGGS. Can you just sort of lay out just sort of more in layman's terms, because this is really technical stuff, to try to even following it through. I mean, reading, I just read through the entire bill, and I'm trying to understand, because it talks about DNA collected from publicly open sources or available in publicly open sources, talks about the STR DNA, the FGG profile, the direct to service genetic genealogical services, CODIS. It's a very technical bill, and I'm trying to understand the overall purpose of providing the protection and then how this does that. Maybe somebody can take us through more just without reading the bill, because I just did that. It's still pretty confusing.
So
It's confusing.
It is very complex, and this is very cutting edge. And we had, if it helps, we had a forensic genealogist, C.C. Moore, who helped to pioneer this, who spoke with the group. We had a geneticist from the University of Maryland on this, and a number of professors who had written on this. So the foundation of this bill was a 2019 policy from the United States Department of Justice. That was the foundation. What we then layered on top of that foundation was judicial oversight, so that if this very invasive technique is used, we'd have judicial oversight. Now, how do you get? So law enforcement, they go to the court. I think it is within section 17102. Law enforcement will show that that they qualify to even get the act. One of the things that was negotiated by the chiefs and sheriffs, they wanted to ensure that if they met this particular test that's under 17-102, that courts could not, so long as law enforcement meets their the test within this bill, you'll have the courts will have to give their authorization. because this technology not only goes after, and this is a term that I learned when we were doing this, the putative perpetrator, or in other words, the person that they believe did it. DNA goes beyond them, it goes into their families and the like. So law enforcement will have a certain amount of time to get whatever information that they have to get. If you're not this putative perpetrator and you're a third party who happens to be related to the suspect, at some point the state is going to be obligated to destroy that information because we don't want them having it. So that's essentially all of that stuff that you're seeing. It's just laying out every detail. We were trying to think of everything that could possibly happen. So again, as I noted, once all of this was explained to our friends with the state's attorney's offices, they had no more opposition to this.
Trying to understand this third party piece. So does that mean, I'm the suspect, and I'm not giving you my DNA because I'm the suspect. So then you find my first cousin or my brother, and you say, hey, can we have a DNA sample to see if your cousin or brother did this, and then they give the sample. That's what that means? That's how the third party thing works?
In addition to that, there have been some incidents where law enforcement had been deceptive about the DNA that they wanted to collect. So they would go to a relative and they would lie to them as to the reasons as to why they would love to have their DNA. So what this bill does is it makes certain that if you're going to some third party, that they have to be given true informed consent to use their DNA for that reason. Because what's interesting, when a lot of this information came out about GEDmatch using DNA, or GEDmatch's system being used to capture people like the Golden State Killer, you had some people who then blocked the use of their DNA, but you had others who said, look, if I can give up my DNA to help capture some criminal, I don't care if they're related or not, I'll do so. So this bill kind of ensures that if you're going to give it up because you want to get that relative that you probably don't know, that it's going to be given up with informed consent. So this bill kind of talks about that as well.
And we restrict, the reason for restricting the types of crimes, I forget, okay, I know there was somewhere we talked about which crimes.
Right, that's under section 17102.
Why do we want to restrict 17?
This is so new, and the fact of the matter is, this technology has only been used for things like murder and rape. There was most companies that allow you to use it, that's all that they allow you to use it for anyhow. But we had one incident where law enforcement went to GEDmatch, and GEDmatch openly violated their policy because they said we could use it for rape and murder, but there was this assault, so GEDmatch violated their policy and said, all right, we're going to allow you to use it for assault. The reason we're doing it this way is because the technology is so new. We just want to use it for the most heinous of crimes until we see really how this stuff is being used. At this point, because it is so new, it's also expensive, so you're really not going to be having law enforcement using this for anything but these types of crimes. So, I mean, all of this stuff was discussed in our work group.
But, I mean, what if there was like a major theft? That wouldn't fall in here. I mean, where was...
I don't know if you would be using genetic genealogy to solve that type of crime.
I mean, if you had a fingerprint from the, I guess that's not genealogy, but you know, the oils where you could
I don't think you would use it for that. And again, one of the reasons why we put the annual reporting in this group of people who are going to be looking at it is as we develop case law and we see how it's being used, if there's room later on down the line to open this up, there's a possibility of doing so. But right now, this is such an invasive technology. I was telling someone just some time ago when they said, you know what, I'm never going to do it because I don't want people to have my DNA. And I said, the honest answer is, if your relatives have done it, some cousin's fault that you don't even know, they have your DNA already. So it's going to be done on you. So what we're trying to do, we're just trying to make certain that that people who are whose DNA is being caught in this, that they have some control, the rest some privacy back. So we're trying to balance privacy rights as well as public safety and the ability for law enforcement to use this technology. And I'll tell you, when I first put the bill in, I tried to prohibit it outright, but again, this is a compromise bill, and I admit it. There's utility to being able to use this technique.
When I'm looking at the top of page 5, line 2 through 5, it talks about the laboratory. Maybe you can just translate this. The laboratory conducting SNP or other sequencing-based testing and genetic genealogists participating in FGS shall be licensed by the Office of Health Quality. So the which one is the SNP? That's the
SNP. What are they called?
Which one are they?
The SNP is the single nucleotide polymorphism.
So is that
now? Please don't get me to try to talk about the science.
No, but is that the genetic? Ancestry.com. Is that who SNP is, or is that the state lab? I'm not sure who SNP. What the laboratory conducting SNP.
So the definition is section 101. 101K, where it talks about that, and I'd be lying to you if I tried to explain.
So no, I got that. That's I'm just trying to understand. Are they like Ancestry.com? Is that an SNP?
No. So those organizations are called direct to consumer. So this is actually talking about what's in your DNA. That's what it's talking. It's talking about those little. It's a sample that they're using.
Right, but is SNP? Is that what Ancestry.com uses? Is SNP? They say they. I'm just trying to see who this SNP is.
They might use SNPs, but again, I'm going beyond my comfort in.
That's what, my question is, because we require that their laboratory has to be licensed by the Maryland Occupational Healthcare Quality.
Right.
But if I'm a national, I mean,
so to your point, the licensing that's going to happen is for organizations that give this stuff over to law enforcement. So those companies, Ancestry.com, 23andMe, when they spoke with me, they said, we don't do this. So, and we had discussions with the Maryland State Police, who were looking to ensure that companies that did this were properly licensed, because they wanted to make certain, again, when you're taking these samples, you want to make certain that it's good evidence that you're even presenting in court. They wanted to make certain that they were licensed properly and that they were doing the things that they needed to do. So language within, I think within the House's amendment, addressed the concern from the Coalition of Genetic Data Protection. They were fine. They're supportive of this bill because their concern has been addressed.
I'm just trying to understand what labs we're referring to. Would we have the ability to license? I mean, if they're national labs, how can they? And we're going to say, well, you got to be licensed in Maryland. And they say, well, you guys can just go away because we're not going to do your licensing.
If you're a lab that's sharing or doing this particular service in the state of Maryland or capturing any of Maryland residents, the state police wanted to make certain that those services were properly licensed. And that's probably about all I can say on that one.
I'm just trying to say, I mean, how do I get them licensed? I'm assuming this is the lab
under 17, what is it, 17104? I believe we talked about the establishment of this Office of Healthcare Quality, and I mean, the establishment of this licensing program for those laboratories that are performing the SNPs or the SNPs and other types of the testing.
But that means, so it,
And one of the things that the state police was concerned with and that we addressed is they wanted to make certain that they had enough runway so that laboratories that were doing this have enough time in the future to get themselves properly licensed. So that it doesn't even go into effect until October 1st of 2024, because we wanted to make certain we had things set up so that they could get licensed.
okay,
Everybody's on board, Castley.
well, I think you're onto a right thing here. I have no problem with trying to make sure this stuff is used appropriately.
Mm-hmm.
I would feel more comfortable if we were doing with like a model national code here or something that's, from
the
NDIS or somebody.
The interesting thing is, no one has done it.
Yeah.
It is based on the Department of Justice's their initial policy.
Right, I got that.
And so one of the hopes within the group was that if we had this passed, this would be a model that would be used nationally. And I think the intention is to then take this and try to have it done federally.
Yeah, okay. I appreciate what you're doing here. I think this is important stuff. I think this is something that we ought to be looking at legislating. I'm just not comfortable that we wouldn't inadvertently. This would be much better if we push this through, some national groups where people get comfortable with this and said, here's how we're all going to do this. And sometimes
Interestingly
taking
enough,
the lead can be a little scary.
You have a lot of organizations that, and this is from, I remember listening to CC Moore talk about it. They say it's the Wild Wild West, and a number of them, they're looking for regulations because you have a lot of people who are entering these industries and they don't know what they're doing.
No, I'm with you. Okay, I don't want to belabor it. I like where I like where you're going. I just don't feel comfortable. And I don't want to hamstring Maryland law enforcement more than other states in the union's law enforcement. And I think it is something that ought to either be, you referred to, we were hoping for national legislation, but if not, at least model legislation coming out with sort of the blessing of, folks on the national level to say this is the way we move forward on this. I'm just uncomfortable with moving forward with Maryland, but I understand. I appreciate it. Thank you.
I think just because it's never been done before, I don't think that shouldn't be a reason why we don't do it. I think sometimes Maryland has to lead. And this obviously looks like the work of a lot of stakeholders. Is that not correct, Charles? And a lot of work, too, and time went into this to develop good legislation. And if there is a problem with this later on, which I don't think there will be, we can always come back and fix it. But I don't think there is going to be a problem like that. But I think Maryland sometimes has to take the lead and not. And the advocates have said there's a great need for this legislation. So I would like to move this forward. Favor.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
No.
Senator Hedelman.
Yes.
Senator West.
Pass.
Senator Sidnor.
Yes.
Senator Jackson.
Yes, and explaining my vote. I'm looking at the proponents of the bill, and I think as the bill came in initially, there was some concern from state attorneys and some others, and as amended, the House version has satisfied those concerns. So I vote aye. Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
Yes.
Senator West.
No.
Chairman Smith.
Yes.
The bill
Okay.
passes
All right.
with amendments.
Bill passes with amendments. Okay, let's to just going quickly. You're near a second. Senator Peters with Senate 666.
Can we change the number?
The devil's bill. Just have the council explain and then.
This bill renames the Court of Appeals as the Supreme Court of Maryland and renames the Court of Special Appeals as the Appellate Court of Maryland. It renames a judge of the Court of Appeals to be a justice of the Supreme Court of Maryland. The Chief Judge of the Court of Appeals is renamed to be the Chief Justice of the Supreme Court of Maryland. There are no amendments.
Just do the roll call.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
Yes.
Senator Hedelman.
Yes. Yes.
Senator West.
Pass.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Pass.
Better not go to dinner last.
Senator Carter.
Yes.
Senator Huff.
No.
Senator West.
Yes, and to explain my vote, I promised the Chief Judge last year I would vote for this. I think I promised it in exchange for her commitment to support something else, but I can't recall.
That's probably good that you can't recall, Senator. Let's keep that off. All right. All right.
Senator Bailey.
No.
Chairman Smith.
Yes. I'm gonna go visit you guys at Double T Diner tonight. All right. All right. All right.
Bill
Oh,
passes
is that tomorrow?
favorable.
All right. Bill passes favorable. All right. We're going to go to Senator Jackson, and then Senator Lee, then Senator Huff. So Senator Jackson, Senate Bill 918.
Senate Bill 918 changes the time within a prosecution must be instituted for commission or attempted commission of a misdemeanor violation of state election laws or the imposition of a civil fine for an unknowing violation of campaign finance laws and certain other state election laws, or civil fine imposed by the State Board of Elections for certain campaign finance violations from the current time, which is 3 years after an offense was committed, to 4 years after an offense was committed. There is an amendment in your voting packet. The amendment adds provisions, among others, requires persons who violate certain provisions of the election law to pay a civil penalty. Actually, it provides that new language that if a person violates certain provision of the election law without knowing that an act is illegal, that they must pay a civil penalty in accordance with the new language. That could be up to $10,000 and would be determined by the state prosecutor.
All right, Senator Jackson.
I think the thank you, Mr. Chairman. This bill was up last year. I think we got caught in COVID. I'm not sure if the Senate heard this bill last year. We heard the testimony this year. don't be, the amendment seems a little, has more verbiage than the actual bill itself. I think in the testimony, the special prosecutors asked for additional time to prepare these cases. I think it makes perfect sense. I think we want to make sure that, as we go through cases that's necessary, that we make sure that we get it right. I'd ask that we move the amendment.
I have a question for Senator Castley, or the attorneys here. So, I guess my question, for counsel or for any of the attorneys here that would know this, there is a common standard, I thought, for how long you typically had to keep records. Because this says you've got to keep them, I guess it moves the liability from 3 years to 4 years. Because if you look at 13-604, it lays out all the different stuff you got to do. Yeah, I thought it was generally 3 years for documents and stuff like that.
Isn't it just like whatever your normal policy is? You just can't alter it. I don't think it's just statutory requirement. I don't know. I thought it was just. Oh, I always thought it was just whatever the normal policy was. You had to adhere to that. You couldn't change it if like you were under investigation or something. But I don't know. You're too.
Counsel,
I
think the amendment is for Title 14 offense, right? And
That's correct.
Business having public contracts. Records are kept for 10 years, actually.
Oh, you're talking about. So what is I'm not familiar. Is that the doing business with the state? What is that?
Yeah, for the business contracts, right, Jeremy? Am I right?
Title 14 is disclosures by persons doing public business.
Businesses having public.
But there's what's the threshold? There's like there's a threshold of money.
Correct.
So I think it's like 100,000.
These are big people. I mean, your campaign, you're talking somebody runs for city council or all these little small things. I don't know. I mean, you're trying to figure out, people are keeping these things for 4 years now.
Years after the creation of the
Seems like up to
record, or
$200,000.
4 years after performance is completed on the contract that caused the person to be doing public business.
So 10 years generally in the +4? Or?
No, so it's until the earlier of. 10 years after the creation of the record, or 4 years after performance is completed on the contract.
Yeah, the records are kept for 10 years. I think it's like $200,000 or something like that. So.
Yeah, so I have a problem with the amendment because, even Senator Jackson pointed out, it's longer than the bill. And these are election issues, and which normally draw wide interest from the central committees on both sides throughout the state, politicians throughout the state, and because it doesn't just apply to us, all different levels of running for office. And to put this through an amendment now, at this stage of the proceedings, that was no advance notice to anybody, I just find really problematic that we would entertain an amendment without giving more notice. My other problem with the amendment is that it provides that it awards stupidity, because it says a person who violates the provisions titled without knowing it's illegal. I don't know anywhere else in the law that we say, well, I didn't know what the law was. This is for lawmakers. We're having a special provision of law that says, for lawmakers, if you don't know what the law is, we're going to change this. I mean, sometimes we say intentionally or unintentionally, and that certainly is relevant, but it's not whether you know it was illegal or not. It also refers to state prosecutor. I believe that state's attorneys also have the jurisdiction to prosecute these crimes. I don't think that it's solely the purview of the state prosecutor. So I just a lot of really strong concerns with this amendment. I think it goes very far. And we're going to have basically a no-hearing bill by considering this. I just think it's a bit much. Thank you.
I'm not trying to hold up. I just want to make sure I fully understand it, and I'm just going through it.
Changing the limitations as well, which is the original bill. And here's why that concerns me, is currently, I'm running for office, I do something that somebody thinks is a violation. They sit on it. Now, but they have 3 years to bring it out. So the first 3 years I'm in office, they got to bring it up. But now they can sit on it and wait till midnight before the election and say, we'll trick you up, you have no response, we're going to go ahead and charge you. If it was a 3-year, I got a whole year to fight back, right? If it's 3 years, they got to file it before that 4th year. Now I got a year to push back and clear my name before the next election. You push it in that 4th year, I'm blindsided. I'm running for election, and now I got to get a lawyer and fight some criminal charge that you've been sitting on for 4 years. I don't think it's good for either party or anybody or society in general.
All right, we think there's some senators who want to do a little bit more digging, so we'll hold it to the end of the, all right. Sorry, Senator Jackson, go ahead.
Can we revisit 842? I know there was some concerns with that. It was Senator Benson's bill. The work group to study the assessment, treatment, and available resources for female youth in contact with the criminal justice system. The request that Senator Benson is making is for a work group. State's Attorney's Office will staff it, and if you look at the bill, it breaks out who is going to participate in the work group, and 842.
I got it. No, I hear you. But I just thought, it's got I think 2 or 3 state agencies in it, and then also there's a question, and I'll ask counsel to look into this. But if that's the case, then I don't know if we need to be involved. I don't know if the General Assembly needs to say, hey, Prince George County, you can go ahead, you go forth and do this. Why can't the county executive just go ahead and bless off and create their own? Counsel, do you have a comment on it, or
Yeah, I can certainly look into it. I guess currently the bill has it staffed by DJS, and the matters that they're responsible for looking into are statewide issues, but you could limit that to Prince George's County. I'm not sure if it would need to be state legislation to do that, or if the county could really do it on its own, having local ordinance require that. But I can definitely look into that for the committee.
I think that the state's attorney, I guess through her research and I believe she believes she needs the authority here to get that done. So if you could, take a look at it and let me know what the concerns are. It's granting of a work group.
let me have him do some research on that.
Okay.
I'm trying.
All right.
Okay, let's do this just for Josh. Senate Bill 569. It's very straight, I think. And then we can do Senator West. Is your 700 pretty? Okay.
So this administration bill alters several provisions that restrict when and how a driver's license may be renewed or a learner's permit may be obtained. Specifically, it permits the extension of an ID card expiration for up to 90 days, repeals a requirement that a copy of a school attendance record required for a learner's permit be a certified copy, permits the MVA to renew a license within 12 months rather than 6 of expiration, it permits the MVA to renew a license without the individual appearing in person if the individual's photograph was taken more than 16 years prior to renewal, and extends the time from 1 to 2 years during which the MVA may accept a certification of acceptable visual acuity from a licensed physician for renewing a license. The bill will take effect July 1st, 2021.
They're like, is this your kid? All right, sorry. Yeah, he's forever young. All right. So is there a second? Senator Castley.
Licenses or IDs, or both?
The specific thing where it's permitting an extension of up to 90 days would be for both a license and a non-driver's license ID. Most of the other provisions deal with licenses or learner's permits.
It says before the expiration of an identification card, you get 90 days.
Correct.
Where's the license?
Oh, you are actually corrected. That is just for the ID card. That's not for the
Okay.
license.
Thank you.
Apologies.
I mean, we'll do this, but where did the 16 years come from? Does anyone know that? Josh, do you know that?
Biological science.
I mean, it's really, I think it's just 2 8-year periods, but where the 8 years came from, I'm not sure about that.
Motion for favorable. It's been seconded. Is everyone okay? No, you're not okay. Senator Hettleman.
So we're going to now have every 2 years instead of every year that a person's going to have to do a visual test. Is that correct?
2 years instead of 1. So if you go to your physician and you get a vision test and they say your vision is good,
Yeah.
basically that will be good for you to go to the MBA and satisfy their vision requirement for
Right.
2 years rather than 1. So it's extending the time that you can use
Right.
that.
So if I'm 90 years old, yeah, if I'm 90 years old and I go, this is, my vision test is good until I'm 92, is that correct?
That would be correct, yes.
I have a problem with that.
Well, you're gonna have to take it up with the octogenarians on the Senate floor. Because they had at it last time, so
Yeah, I know. Well,
they carried
to
the
play
day
this
last
game.
time. I don't know.
to complete this game. I mean, seriously?
I'm not taking an age amendment. I will resist that.
Take it up with the octogenarians on the Senate floor. All right.
No, I'm serious.
No,
mean,
I know you're serious. I know you're serious.
Yeah, this is problematic for public safety, I think. Every year.
Every year.
It was.
Please, someone second it. Let's move on.
Second.
All right, we'll roll it.
Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Castley.
On behalf of Mr. Magoo, I vote yes.
Senator Hettleman.
No.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
Yes.
Senator Huff.
On behalf of keeping my picture from when I was 30 another 5 years, yes.
Chairman Smith.
Floor fight. Yes. All right.
Bill passes.
All right. All right. So now we're going to early. Oh, sorry, Senator West, then Lee. Sorry, Senate Bill 700, then Lee.
So this bill alters provisions governing the custodianship and deposit of wills by establishing duties and requirements applicable to a custodian of a will, allowing a person having custody of a will other than the testator or the testator's agent to deposit the will for safekeeping with the Register of Wills, and authorizing an attorney to dispose of a will in a specified manner under certain conditions.
Thank you, Mr. Chair. This bill is the bill of the Estates and Trust section of the State Bar Association. It's a lawyer's bill. It really doesn't affect consumers at all. It's what do lawyers do once a will's been signed and they have this will in their possession. The current law provides certain information about what they should do, but it's not comprehensive. So this bill fills in the gaps. So any lawyer who has a live will in his possession or her possession knows exactly what he or she can and should do with it until the testator dies. That's what this bill does.
No amendments.
Okay. All right. Who can tell me what the bill does?
Tells them where they put the will.
Yeah, there you go. All right. Senator Lee, Senate Bill 675.
Do you want counsel to explain the amendments first, or do you want me to just? Okay. Counsel, you could kind of, back me up on this after I'm done, okay? The bill was came out of what we call the work group to study child custody and court proceedings involving child abuse or domestic violence allegations. This is the final report. This work group was led by Secretary of State John Woven-Smith, and it had a lot of the stakeholders that are involved in this area, which is a very complex area, dealing with what you do when we have cases dealing with child custody and there's domestic violence and child abuse, which sometimes there are terrible outcomes that come out of that because perhaps maybe the judges were not familiar with this issue in particular, and in some cases the child who was subject to abuse was given to the abuser. You heard witnesses, more than one, come in to say about how the abuser got the child, full custody of the child, and even when the protective parent tried to protect the child, that was used against her. I think that this was a very sincere effort to be able to address this issue. The intent was to ensure that judges are equipped with the necessary training they need to deal with these custody cases involving child abuse and domestic violence, which is different than just regular custody cases. We did not want the abuser gaining that custody of the child and further abusing that child, so there's lifelong damage, psychological and physical damage. The hearing had a number of cases, as I indicated, where there was even an abuser who was convicted already, but unfortunately, custody was given back to the abuser. Judge did not even ask further questions, and this is just about those types of cases. I think a similar case was raised in. There was an HBO special done on Allen versus Farrell case. You could watch it later. Like I said, it's just a training bill. It's not unconstitutional, and I think the judiciary is mistaken in its interpretation. The amendment replicates what judges have to do in SINDA cases. It's already current law under SINDA cases. One judge per county assigned with training. As I said, not unconstitutional, doesn't violate separation of powers, and the language is already based on existing law and is at the discretion of the judge. Other states have this training for judges, Texas, Minnesota, California. We just want to provide judges with the necessary background and training they have to get them through the smoke that is involved in a lot of these child custody cases involving these types of incidents. We also have for best interest attorneys that they get 10 hours of training every 5 years. Counsel, do you want to elaborate on this?
Okay, so the bill as amended requires that in each county, one or more judges shall be assigned specifically to hear certain family law cases that involve domestic violence or child abuse. And the bill specifies certain qualification for these judges and specifies that their training may include certain topics. The Maryland judiciary shall make educational and training materials relating to the training of these judges available upon request. Additionally, the bill specifies that individuals who serve as a child's counsel, which is defined as child's best interest attorney, child's advocate attorney, or child's privilege attorney, these individuals must receive initial training, but the bill no longer specifies how much training these individuals are required to receive. However, they must receive 10 hours every 5 years of ongoing training.
Everyone knows what it does. Further discussion? It's from Senator Castley.
The Chief Judge's, Judge Mary Ellen Barbera's memorandum, which she rarely herself takes on these memos. We usually get someone else on the administrative side, but in this case, Judge Barbera herself, who's often comes before this committee, did a 3-page memorandum setting forth in detail her concerns with this bill, not the least of which the violation of the Constitution and separation of powers. I just think that we ought to give Judge Barbera's, she's always been very straight with us, and a lot of respect for her, and I think we ought to really give her concerns about this bill more than just a passing recognition. So I just bring them to the forefront. And I would just point out for the body that the judicial branch does have an extensive training programs that all new judges and judges who've been out for a while go through to educate them in all the various aspects of the law. And I don't think that they would benefit by the legislative branch trying to micromanage that piece of it. So thank you.
I just have a question for counsel. Where were the domestic violence advocates on this, like Dorothy Lenig and those folks?
Was the
amendments might fix some of their concerns.
So there were advocates in favorable and then also advocates unfavorable, so that you had both sides from the advocates.
The Maryland coalition against.
So, for example, House of Ruth Maryland is informational. Maryland Judiciary is unfavorable. Women's Law Center of Maryland, unfavorable. Maryland Network Against Domestic Violence, unfavorable. Maryland State Bar Association Family Law, unfavorable. Favorable with amendments, Rain. University of Michigan School of Social Work, favorable. Center of Hope Life Bridge, favorable. So on both sides you have favorable and unfavorable.
Response to the bill before it was amended. As I indicated earlier, we're not trying to force the judges to do this, but our intent is to give them those tools that they need to sort out these custody cases where there is abuse or domestic violence. That's all we're trying to do. And we're trying to provide some something that they will give them that extra, because right now sometimes it doesn't happen that way. And this amendment already replicates what judges have to do under the child in need of assistance cases. So we're not making really new law. It's like I said, one judge per county assigned with training. Doesn't violate the separation of powers. Language is already based on existing law, and it is at the discretion of the chief judge. And we're just trying to equip them with some tools to be able to sort through these child custody cases. And it was based on this work group headed by our wonderful secretary, John Wobensmith, and with some of the stakeholders that actually do this every day. So I ask that our committee move favorable on this as amended.
We had a motion and a second. It's unfavorable.
Well, yeah, that's right. Senator Parton, do you want to go? There was a motion on that.
She made the unfavorable, I seconded it.
So we'll just run that first and then we'll go Senator Parton, anything else to say? Good?
I was going to ask questions, but I'm not. I would apologize to the sponsor. I know she believes in the bill. I think it's very much an overstep. I could talk on, but I won't. I just move unfavorable.
All right, so
Okay. Oh, sorry. Vice Chair Waldstraker,
No on the unfavorable.
Senator Lee,
No.
Senator Castley,
Yes.
Senator Hedelman,
Yes.
Senator West,
Yes.
Senator Sidnor,
Pass.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
Yes.
Senator Huff,
Yes.
Senator Sidnor,
Yes.
Chairman Smith.
no on the unfavorable.
Bill fails.
All right.
Yeah, I don't know.
Okay. That's that.
Senate Bill 852 is an emergency bill. It does a number of things. It alters provisions and penalties pertaining to several firearms-related offenses. It also expands the definition of a crime of violence under Section 14101 of the criminal law article. It requires the Commissioner of Correction to provide inmates with reentry kits containing certain items and information prior to release from a state correctional facility, and expands the list of cases in which the state may appeal from certain evidentiary decisions. The bill also prohibits a district court commissioner from authorizing pretrial release of certain defendants and specifies that a violation of a condition of probation, parole, or mandatory supervision involving the use or possession of a firearm is not a technical violation. There are several amendments in your voting packet. The first will do Amendment 548, 478 strikes first a provision of the bill beginning on page 9 of the reprint, which provides for specific prohibition and penalty for theft of a firearm. Or actually, excuse me, prohibition and penalty. It provides that a person convicted of theft of a firearm, including an antique firearm or replica, is guilty of a felony, and on conviction is subject to imprisonment not exceeding 5 years, fine not exceeding $10,000. So it strikes that provision and also strikes a provision beginning on page 12 of the bill that alters the current statute governing release by district court commissioners. Current law provides that a district court commissioner may not authorize a pretrial release of a defendant charged with certain crimes if they have previously been convicted of a crime of violence or certain enumerated crimes. What the bill would do is change that so that the existing law stays the same, but in addition to prior convictions, individuals who are on pretrial release for a crime of violence or one of those specified crimes would also be ineligible for release by a district court commissioner. So this strikes that.
No, this is a committee amendment.
I'll just get to the section on the one second. Okay, so if you turn to page 4 of the reprint, provides, starting at line 11, that before release of an inmate from a state correctional facility, the Commissioner of Corrections shall provide the inmate with a reentry kit that includes at least 1 week of supplies for basic human needs, including toiletries and clothing. The identification card required to be issued under existing law, contact information for entities that specialize in providing reentry services, housing assistance, substance use disorder treatment, and mental health services. And if the inmate is not eligible for Medicaid benefits, contact information for the Maryland Health Benefits Exchange. Additionally, required in that packet is public transportation information, including local public transportation schedules and maps. And if the inmate is eligible for Medicaid benefits assistance, shall assist in obtaining Medicaid benefits.
Senator West.
Is this the bill that we passed last year and went over across, but because we adjourned early, they never got a chance to deal with it? Okay.
Well, they did not take it up. So yes, so the bill as drafted was drafted exactly to the third reading version, which I think in this committee, I think Senator Carter may have been a no. I don't remember, but I think everybody else was voted yes then. It was the governor's bill that we had adopted onto mine. We passed it as this, and then basically they asked me to put the bill in again. They came in favor of it. I thought it was a good product last year. I think it's something we should address. Quite frankly, all the reasons that we passed it last year are still here. I mean, you had the mayor of the city of Baltimore come out and said that violent crime, and we're talking about handgun violence, is an epidemic in the city, or a public health crisis. So all the reasons are there. I would ask for, on the committee amendments that are adopted, I'll take those as a friendly. I know it takes out 2 provisions of the bill, but in order to move this forward, I will take those as friendly. So I would offer to accept I would make the motion to adopt the amendments on 852.
Second.
And then while my mic is still on, I'll go ahead to get it moving. I'll make a favorable on the bill.
Does that mean my amendment too, Senator Huff? Okay.
So that amendment is for Senate Bill 852. The amendment number is 853-920/1. The amendment alters the volume dealer statute specifically the penalties for the volume dealer statute, and provides that for the current penalty, which is that a person who's convicted of a violation must be sentenced to imprisonment not less than 5 years and a fine not exceeding $100,000 is changed to instead.
Where's the read? I don't have the actual amendment that you read off. Where are you on the reprint?
Sorry, let me
I don't
pull that up. It is page 7 after line 32 of the reprint. So if you go on to the page that's after page 7.
Dealers. I mean, the bill doesn't address volume dealers, so why is her amendment addressing volume dealers? I have a question for the sponsor then. So the bill deals with firearms, and the portion above it makes it a felony if you possess or use a machine gun. You're changing volume dealers. My bill doesn't touch volume dealers, doesn't make a change in it. So why do you want to change volume dealers?
This deals with, this section deals with I want it to not have always the mandatory minimums. If you go to page 3 of 3.
I don't add any mandatory, the bill doesn't create any mandatory minimums. Any mandatory minimums now are ones that are currently in law. So you're trying to get rid of a current mandatory minimum on volume dealers?
Yep.
Because the bill doesn't create a single mandatory minimum.
Well, it's a mandatory if they do possess a firearm.
No, I mean, I don't, well,
So I appreciate the intent of the sponsor of the amendment, but this isn't germane to the bill, and we didn't have a hearing on it. So the bill as introduced has nothing to do with volume dealers. We're saying volume dealers is, I mean, what most people call this is the kingpin statute, right? This is most definitely the kingpin statute. And so I'm not sure why we'd go out of our way on behalf of drug kingpins when the bill as introduced doesn't have anything to do with that, and we didn't have a hearing on it. So I'm open to this idea on its own bill, but adding it in at the last minute.
So to back up too, now this is bringing up back a memory. We years ago actually got rid of, I was part of this, we got rid of mandatory minimums on a lot of these drug offenses, but we've always carved out, and you always carve out drug kingpins. So when we created the safety valve, and we got rid of them, and then we did JRI, we straight up just got rid of mandatory minimums on this drug stuff, except kingpins you always carve out. So I don't want to get involved in that, if that's what this is changing.
Favorable. All right, so the motion's favorable with amendments. Vice Chair Wildstriker.
Yes.
Senator Lee.
Come back to me.
Senator Castley.
Pass.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
No, and to explain my vote, this looks like another mandatory minimum bill.
There's not a single mandatory minimum in the bill. That's factually, I can't let that stand. That is factually incorrect, what was just said.
Is guilty of a felony on a conviction is subject to imprisonment not exceeding 5 years.
There's not a single new mandatory minimum in the bill.
No.
And if the chair, if they could clarify that, because we went through this on the floor last night, or last year, and it was falsely attacked as such.
I'm sorry, Senator, which provision were you looking at?
Come on, H. Guilty of a felony and or conviction is subject to imprisonment not exceeding 5 years. H1.
I thought Larry's people talked to you, Michael, on this bill.
Nope.
Which page are you on, Senator?
H1, page 9.
Page 9? I'm not sure I heard you right, Senator.
The interlocutory appeal is taken out.
I'm on page 9. Senate Bill 852, page 9, H 1.
Right, so that's struck by the amendment.
That's all struck. Okay. All right, pass on me.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
Senator Lee.
No.
Senator Cassidy.
Yes.
Senator Jackson. Senator Jackson, do you want to vote, or do you just want to abstain?
I'm not going to abstain. I'm just trying to make sure I know what I'm reading.
So the bill, you went down, but the bill passes, so. All right, we'll go on to, just real quick, because I know you got to report it. If you go to Senator Heddleman. 6-5. Senator Heddleman.
6-5, it was 10-1 last year.
Senator Heddleman with Senate Bill 582, and then we'll go on to 691. We got to pick it up a little bit just because we're running out of time.
Bill, are we ever going to get to the JJRC bill? It's at the bottom of the list.
You mean 853?
Are we going to get there today, you think?
Yeah, we'll tag on that. So right now we're just waiting we're going to do 852, and then we'll go to Senator Hedelman 691. Sorry, you're right, 582.
Should I read the bill? Yes, please. Senate Bill 582. There is one amendment in your packet. This emergency bill establishes that a personal liability clause included in a commercial lease is unenforceable if, as a result of the governor's declaration issued March 5th, 2020, or other proclamations related to the COVID-19 outbreak, the tenant was required to either cease serving food or beverages for on-premise consumption or close to the public because of its status as a non-essential business, or a specific provision contained in the executive order or proclamation. And two, the default caused the individual to become wholly or partially personally liable. And that occurred between March 5th, 2020 and September 30th, 2020 inclusive. The amendment, there are two changes in it. So it alters the sunset provision in the bill. So the bill will sunset 180 days after the expiration or the rescission of the COVID emergency order that the governor has in place. And then the other amendment, so it makes a personally liability clause, it may be enforceable instead of under the bill, which is currently it shall be unenforceable. So it goes from a shall to a may.
Thank you, Mr. Chairman. So the purpose of this bill is to respond to tenants who have personal liability clauses in their commercial real estate contracts. And this really, with the amendment, it enables the judge to take into consideration the full totality of what is happening in the world at the moment. It does not in any way absolve a tenant from what they owe the landlord. It just allows the judge to look at the personal liability clause, to determine that it may or may not be unjust, and to make decisions about that. And again, it also kind of puts guardrails on the time that we're in now, and given that we're in the middle of a public health emergency, so it does sunset. But so I think it's narrow, it's targeted, and it's addressing some concerns that some of our constituents have right now.
No, I appreciate the bill, and not only because one of the examples used was a constituent of mine, a friend from back in Silver Spring, but I just appreciate you bringing it up. So thank you for that, Senator West.
Thank you, Mr. Chair. I guess my question is this constitutional? These people have entered into a contract. The contract is in existence. They've each relied on the provisions in the contract up until this point. Does the General Assembly have the power to invalidate provisions in existing, not future, but existing contracts between private individuals?
So there was a court case in New York, and they determined yes, that it was. And I shared that case with Senator Casserly when we had the hearing, and so I'm happy to share it with you too. But again, this is not mandating.
Was the New York court case based on the U.S. Constitution or some provision of New York law?
I don't know if the constitutionality of it was contested, but they did allow the local statute to continue. So, and it was addressing current contracts.
Do we have an Attorney General's opinion on this?
Actually, that's a good question. Can't recall if we do.
I just was unaware that the state of Maryland had the power to invalidate existing contracts between private individuals.
Again.
What was that?
The adoption bill, we just did that. And you voted for it.
I feel suitably rebuked, but
I don't have an.
Do you have the case site? Then you could look it up and.
I can send you. Let's see.
Wait a minute. Now that I had 30 seconds to react, That was not a contract between the adopters and the baby who was being adopted. The baby wasn't a part of that contract.
I'm sorry, I'm having trouble finding this site right now, but hang on. Yep. Okay. It is. Oh, I even have the Lexus. It's Melendez versus the City of New York.
What was that?
Melendez, Melendez versus the City of New York. It dealt with 3 issues, one of which is a law protecting commercial tenants from, a law concerning personal liability provisions in commercial leases.
Let me try to look it up. Could we maybe hold this for a little bit, and while I look up this case, and in order to avoid time, if I can find the case, I'd like to read it.
Okay, got it. We'll hold it for, we'll go on to the next one, then we'll go on to Senate Bill, and then I think this is Council Marcioni, Heather, Senate Bill 691. Actually, so just picking up on the conversation about that, I spoke to a couple people here and then some other places that are talking about like the multiple dings and inquiries during the process of kind of shopping around for a place to live or to rent. And one thing that was brought up that was never, I just didn't think about it, was just the potential impact on a credit report. Because if you have several inquiries, how that can ding your credit report. That was actually that was a practical, kind of small thing that I never thought about. But anyway, Heather, if you could just catch us up on the bill again, and then we'll go back to Senator Hedelman.
So this is a bill that JPR previously discussed during voting sessions. So this bill requires a reusable tenant screening report to contain specific information regarding a prospective tenant. It requires a notice regarding whether a landlord accepts the report and prohibits a landlord from charging specific fees related to the report. There were 2 amendments for this bill. There is a sponsor's amendment, which conforms to the House version of the bill. And then there was one amendment from Senator Huff, which deleted the prohibition on collecting a fee by the landlord.
I can't recall. When we considered this before, did we adopted the amendment? Is that correct? The sponsor's amendment?
I don't think. No, I don't think we did.
Okay.
Do we conform to the House yet? Do we do that yet?
Yes, hold on, we had a.
So that's my amendment, is to conform it to the House. Okay, so, right. So I'd just like to, can I speak to them? Okay, so so a couple things, and I did want to respond to some of the concerns that had been expressed at the time, and we shared some additional information and sent it out. So these in Washington State, where they've been doing this for a few years now, they have found that they're especially helpful for service providers who work for low-income clients, and to help them to prepare the reports and to gather the information that they need to submit. And they did see an increase in the use of them with nonprofits who are working with the homeless, as well as with social workers and their clients. They also do help landlords comply with fair housing laws, and I know the chairman sponsored a bill last year on discrimination against source of income, and it does help in terms of the screening for landlords with regard to that. So there are nearly 200 landlords in the state of Washington who use these. It doesn't mandate that they use these, but again, I do think that this is a helpful tool to tenants that will save them some money and make it easier for them to in their search for housing, especially at a time when we're going through challenges with regard to lower income people finding stable housing. So I would urge the committee to, I'd move the bill.
All right, seconded. All right, do you want to do a roll call on this? Let's do a roll call. All right, roll call.
691.
Sure, of course.
Protracted debate on this. I thought we were actually going to defeat it last time, but let's say briefly, no one's going to use a form that they can't charge for. So Bill says they may use it, which they can already do now, which is currently the law, and then says they may not charge for it. Why would you use a form that you may not charge for? I think it's a disincentive to use it. So I think at most the bill doesn't do anything because you can already use a form already, and by saying you can't charge for it, it's a disincentive to use it. So I think it's not a good idea.
To respond to that it actually, it saves the landlord the money for doing the screening themselves. So you wouldn't charge for something that you're already providing to the landlord. So we're helping the market. I think it's been moved and seconded, right?
Yeah, so since it is voluntary, and it does require that you disclose, the landlord has to disclose promptly, conspicuously, whether they accept it or not, why wouldn't it just simply provide that the landlord has to state whether they accept it and also state conspicuously whether there would be a charge for accepting it? I mean, in some rental markets, the landlords may find that putting a fee on that, people don't use it. And doing it for free, people use it. In the other demographics, where the higher end people say, that's fine, we'll pay the fee. Just don't know why we would have to, we gotta let the market decide. No problem with promoting the use of these pre-screening reports. That's an awesome idea. And no problem with putting it on the web page, whether you do it, that's an awesome idea. But this easy solution here, just to say, put on the web page that, and if you do put on the web page, you take it, you got to put the fee that you're going to charge, and let the market decide. Because then, if this is a great idea, landlords won't be charging a fee for it, and they'll use it widely. And if charging a fee is a bad idea, people will shift towards no fees. So I prefer carrots and not sticks. Thank you.
Want to favor with amendment, Vice Chair Waldstreicher.
Yes.
Senator Lee.
Yes.
Senator Casserly.
No.
Senator Huddleman.
Yes.
Senator West.
Yes.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
Senator Bailey.
No.
Senator Carter.
Yes.
Senator Huff.
No.
Chairman Smith.
Yes.
Bill passes. Favorable with amendment.
Bill passes favorable. Okay, great. We're on to Senator Heddleman, Senate Bill. $582. Heather, so go ahead, Senator West.
Yes, I found that there was a U.S. District Court case for the Southern District of New York in which a similar provision was held constitutional under federal law. It was indicated that the case was likely to be appealed to the Second Circuit. I can't find any evidence that the Second Circuit has ruled yet. That's not,
I don't know that they have.
it doesn't look like. If they had, I'm sure I would find it online. So apparently, there's no final decision. Whether or not it's constitutional, I just think it's a bad idea. Unless there's a serious need to invade contracts, and I don't see in this case we're talking about a very serious need. This pandemic is winding down by the end of April. I don't know when this is going to take effect. It's an emergency bill, right? So it'll take effect soon. By the end of April, we're going to be awash in vaccines. And so I'm against it.
Thank you, Mr. Chairman. So I'd just like to respond in terms of why the urgency. We heard from somebody who had a REIT, who is his landlord, who had a fine relationship for, I think it was 8 years, and now they're going after his, like, album collection, he said, and they're going after his livelihood. I mean, his home, his cars. And so for somebody who is in the midst of something like that, there is an urgency. And so I would at least like to give the court the opportunity to consider what he's going through, or somebody like him is going through in the context of this pandemic, to, address those real life kind of emergency issues. Again, it's not saying that he's not on the hook for finding that money. It's just that it does provide some protection from, again, it's sort of this nameless, faceless Reed out there who is his landlord from going after his personal effects. And I understand, I've talked to some commercial landlords, so I understand the reasons why people put these provisions in contracts. But again, I think we're in an exceptional circumstance, and I think there are sufficient guardrails on this particular provision to deal with this particular emergency. But, I understand the issues about the contracts, and I understand, their need and the reason why certain commercial contracts are created that way, structured that way.
So I guess my follow-up then is, as I'm reading the amendment to the bill, it says the bill will last through 180 days after expiration or rescission of the governor's emergency declaration. In Maryland, we have a 3-year statute of limitations. So I guess there is a concern that if there was a breach of the lease, which would give rise to the ability of the landlord to go after the personal guarantee, and this 180-day period were to run beyond the 3 years, the landlord could lose his right after the end of this bill to go against the tenant, the defaulting tenant. So at the very least, I think we should include in this provision a bill that would extend the statute of limitations in these situations until 60 days or 100 days, 90 days after the bill ceases to be effect, to let the landlords have that opportunity to come back against the tenants at that time.
We adopted the amendment the last time. The motion was favorable to the amendment.
That was a different bill.
Oh, so do you have another amendment for this? No amendments.
No, there's an amendment. To conform it to House.
Did we adopt? I thought we adopted that.
You're thinking of the other amendment.
Did we adopt this one though?
No.
Okay. Do you want to adopt it?
To adopt the amendment.
Okay. Second. Everyone's okay? Great. Senator West, you would like another comment?
Oh, I'd never turn my light off.
Oh, okay. No
But
worries.
if we wanted to hold the bill briefly, I could get an amendment prepared to add the statute of limitations extension that I just talked about.
So I guess I have a question. So
Why would we, if we know that they owe, right, for the period of time, even if the statute of limitations should expire, they still owe that, correct?
Yeah, but the guarantee could not be enforced. You might owe it, but they've lost the right to sue to recover the money.
The landlord has lost the
Right.
opportunity after 3 years.
Yeah,
But
that's what statute of limitations mean.
Yeah.
If you fail to file suit within the period, you no longer have a right to file suit.
right, but why are you expecting that they wouldn't file suit in the 3-year period if you know that
Well,
they
this-
already owe?
But I think your bill says that they don't have the right, right? Isn't that what the bill says?
No,
What am I missing here?
they may.
I'm missing the middle page of the bill. Sure.
That would be helpful.
Which council are we talking? Is it Heather? So Heather, my concern is, under the bill, it's an emergency place. It would say take place soon. It says it will continue to preclude landlords from suing under these guarantees until 180 days after the expiration of the governor's executive order. If the expiration were to occur 3 years or more after the landlord, after the right to sue the tenant accrued to the landlord, the statute of limitations would run, would it not? And the landlord, unless we change the statute of limitations and extend it in this situation, the landlord would lose the right to sue under the guarantee.
So the landlord's not prohibited from suing at all. Under this bill, it says a personal liability clause may be unenforceable. The landlord could still sue to collect the rent under any other scheme, just that liability clause may be unenforceable.
Well, why would a landlord want to sue on the basis of an unenforceable clause?
I would assume that there are other provisions in the contract where they could collect the money from the individual. But then as to your question about the statute of limitations, so the amendment, it does, under the bill as introduced, there was a specific deadline or a specific sunset, which was 2023 when it sunsetted. And then under the proposed amendment the amendment that was adopted, it is 180 days after the current emergency order expires. So theoretically, yes, the emergency order could expire in 3 years from now, and then the landlord would not have the possibility of suing under a personal liability clause. So
Right. So
technically, yes.
Could we not adopt an amendment to this bill which would extend the statute of limitations in these situations until 190 days, 120 days after the expiration of the governor's executive order?
That would be a policy decision.
Yes, but I'm just saying we could do that if we wanted to.
It wouldn't be unconstitutional.
Exactly. Okay, thank you. Hi there. I'm in a voting section, but I just finished expressing my views, so I can talk. All right.
The only other thing I'd like to say is that there are other ways for the landlord to get what they need. I mean, there's repossession, there's late fees. We're just talking about this one specific, pretty narrow personal liability clause. Thank you.
Yeah, so tell me if, as I look at the bill, Heather, the personal guarantee becomes unenforceable forever, as I read this bill, if at some time during the course of the tenancy, as a result of the governor's executive order, the establishment had to cease serving food and close to the public. Once those two conditions occur, then the personal guarantee, in essence, is defunct. It goes away. It's no longer of any force.
I think it would depend on the court's determination, because the amendment changes the shall to a may in line 3. Yes.
All right, we got to do it like now, right?
Yes, the court would have the discretion to decide
Okay.
whether or not.
So I mean, there's no nexus in here, but given that it's a may, I guess the court would infer a nexus, that there had to be a nexus between the closing and not. I guess my next problem is, it says a commercial landlord may not attempt to enforce a personal liability clause that knows or reasonably should know is unenforceable. So now the landlord, I mean, this gives the court discretion. So how could you give, if the court may, in any case, the court may and the court may not. I'm not going to know as a landlord until I file suit. I can speculate I can say good chance or bad chance, but since it's a may, how can we possibly preclude a landlord from filing suit if it's a may? And how can we award, go ahead.
I see the point that you're making, lines 16 through 18.
16 through 21, really, because it says I can't even bring a lawsuit, and if I do bring a lawsuit, I can be liable for the lawyer's fees and costs for the other party. So I'm stuck in a difficult position because I'm not sure if the court would enforce it or not because it's a may. But if I guess wrong, boom, I get whacked with fees and I guess sanctions because I'm not sure how those work. I don't know how you make 16 through 21 read now that you've amended this to a may enforce under line 3. It seems to me those are mutually inconsistent.
Yes, it would conflict because the landlord, so line 16, a commercial landlord may not attempt to enforce a personal liability clause that the commercial landlords knows or reasonably should know is unenforceable under this section. By making it a may be unenforceable instead of a shall be unenforceable.
Yes, I mean, I think you have to either go back with the shall or delete 16 through 21, right?
I think deleting 16 through 21 I wouldn't say it's a technical change, but I think that would conform to the may if that's the request of the sponsor or the committee wishes. I don't think that would conflict.
Yeah, I was really troubled by the shall be unenforceable language because it didn't require a nexus, but I'm going to infer that the court's going to find a nexus or they wouldn't grant it. I mean, they're not going to do something stupid. So now there's a nexus. I'm good with that because it's sort of, to put the shall was troublesome. But now that I'm with a may, it ought to give me the discretion to file suit. Now, in any suit, if I bring it in bad faith, then there's always sanctions for bad faith. But given that there's the doubt, I really think we have to delete 16 through 21 to go forward with this. I don't have an intellectual problem with this because it's just simply giving the court the discretion to basically, I differ from Senator Weston that the governor came in and trounced, I'm not saying this negative to the governor, but let's say the state came in and trounced on the constitutional right of the land, of the store owner, the tenant, to operate. And so I have no hesitancy in going down the line and stomping all over the landlord's rights, equally. So I catch where Senator Hedelman's coming from, but I think that we should delete 16 through 21 and go with the rest of the amendments. Thank you.
Because I don't know if you realize this too, that in line 15, just above it, there is the amendment says the court finds, based on the totality of the circumstances, that enforcement of the personal liability clause would be unjust.
That's fine.
So, okay.
It's just that then my problem is 16 through 21. 16 to 21 are sort of punitive. The landlord's not going to know. They're not going to know all the facts. They're going to file suit, and then the court's going to make a decision, and they're going to live with it. But to say, well, we normally say you can't file suits for bad faith, things like that. But this is a very fact-specific case because you have this tendency in there. I don't know whether you quit serving because you said, I'm going to take advantage of COVID, and that may come out in the case. It may come out in the case that there was absolutely no reason to go into default, and the landlord can establish that clearly, and the tenant just said, opportunity knocks. I'll avoid the lease on COVID. If the court finds that, if the court concludes that, they're going to say, no, you're not going to be able to take advantage of the disease. Right. So I just think that it'll be a lawsuit, and the court will hear it, and the court will have discretion to grant the relief, as you suggest, for the tenant. I just don't want to then turn right back around and say, but if you fine for the tenant, you could slam the landlord with this other stuff. I think that goes too far.
What if we kept shall? Would you would
delete 16 through 21?
No, if we keep 16 through 21 and put the may back to a shall.
I don't like that at all because the problem with the may is great because the problem you have right now with shall is all I got to do is show that for one day I closed and for one day I cease serving patrons. Automatically, this says that my personal guarantee is unenforceable, and once it's unenforceable, is permanently unenforceable. And it would continue to go, once it's unenforceable, in my view, it's dead letter, and even a year after the pandemic's over, it's already dead. We've already said it's dead. The courts strictly construe personal guarantees in favor of the person giving the personal guarantee. And I wouldn't want to mess with the personal guarantee, the viability of personal guarantee. I think you right on with the may, because we don't want to just throw the thing out. You could really screw over a responsible landlord in favor of a really irresponsible tenant. So I think you have a good bill here with the may, but I think the 16 through 21 is just no longer fits. Just my suggestion.
Thank you, Mr. Chair. As much as I hate to disagree with my learned colleague two doors down, I've never heard of providing that a judge may. The judges have to have some direction. Otherwise, you're going to have one judge who says, no, I'm not going to grant this, and the next courtroom down, given the same set of circumstances, a different judge said, yeah, I think it makes sense, I'm going to grant this. And all across the state, you're going to have some judges which grant it and other judges that don't. That's not a law. That's license to the judges to exercise their personal predilections.
I can respond briefly that look, the guy who got shut down, the gal who was running that little restaurant and got shut down, that just trounced all over the Constitution. It trounced all over the contract. And now we're going to pretend that those two things didn't have. To give the judge the ability to step in, is it equitable? You know what? It is sort of equitable. It's somewhat equitable, but we're not going to call it that because we can't give equity in these things. But how do we put the tenant on the same footing as the landlord? Because the entire risk, the entire burden, the COVID burden, without Senator Hedelman's bill, the entire burden, all the risk, the burden of COVID falls on the tenants. And the landlord can skate by. And I just don't know that was ever the intent. I mean, we just smashed the constitutional rights of those businesses to stay open. And was it justified? I don't know. I'm not a scientist, but we did it. And so to say, yeah, but when it comes to the landlord, by God, the Constitution and the contract are going to be sacrosanct. Like, come on, if we're gonna play by those rules, we ought to give the court the ability to look at it and say, you know what, we're not going there. So.
Yeah, I'm scratching my head as well. Like, I wonder, was there a reason? Did the sponsor tell you why they took the May? What was the reason?
I think just to give some more flexibility to the judge. Yeah.
Yeah, just because it does create that inconsistency, but.
Yeah, but without the May, when you look at the bill without the May, all I have to show is the tenant is I was running a restaurant, and at some period, I got closed. Whether it was for a day or a month or 3 months, I got closed. Once that happened, boom, my personal guarantee is gone. And it's gone forever, because you can't say it's gone and it came back. It didn't come back. It was gone.
Here we go. So the House bill is on its way over here. Senator Hedelman, we're just going to hold off on this. If we're going to have a fighting chance getting this stuff on the floor tonight, we got to cut chop soon here. So let's go ahead and cut it for the evening so the council can prepare for the floor session. The House bill is on its way, and we'll move them in tandem, if we can figure this out. Tomorrow, I don't know what floor is going to look like or if there will be floor, but I do want just to highlight we are going to be focused primarily on Senate Bill 88. And so just be prepared for that discussion coming up tomorrow. So I don't know what floor is going to be like, but Senate Bill 88 will be the central focus for tomorrow's debate. All right, have a good one. All right, floor leaders for the stuff we passed. Just real quick, can you listen to Sandy real quick for floor leaders?
All right, Wade's Law.
Senator Westland, Wade.
Senator Sindor, do you want your DNA bill?
Yeah.
Senator Lee, Love is No Defense. which is no longer Love is No Defense. Okay.
It's like our 80s rock song.
Access to birth and adoption.
That's the lead.
Senator Peters, child abuse and neglect.
Who wants Senator Peters?
Memorandum of Understanding with Military
I'll
Family
take that.
Advocacy Program.
I'll take that. Get that bond.
He already got it.
Senator Heddleman, Victims of Crime, Private Room. This is the administration bill, driver's license, learner's permit, instructional permits, and identification. Huh?
No.
Would you like that one?
Hilarious. That would be so funny. All right.
Senator Huff?
No.
No?
Fine, I'll take it, whatever.
Okay. Or anybody else? No. It's all you. Senator Peters, Court of Appeals and Special Appeals, renaming Senator Carter.
Legislative sessions, but it's no pressure from me. I was just asking.
Sorry. It's okay. Senator Reedy's motor vehicle inspection certificates exception bill.
Castle, you want that? No?
Bob will take it.
All right. Okay, Bob. Is it okay?
I'm okay with it.
He sits by Reedy in case they have an issue.
Senator Heddleman, the reusable tenant screening reports. Senator West, Estates and Trust Wills Custodianship.
Sure.
And then Senator Huff, Violent Firearms Offender Act.
What? You should take that. Come on. You did a good job on that, Will. It's gonna get tore up. You know, man. It's gonna be all your caucus. You're not gonna take it?
All right.
You had it last year.
I know.
And you did a good job. It passed with 4 to 7 votes.
You'll do it? Okay.
I mean, it's only going